And my lord, the judgments, which are not common to my lord what was already filed before us, are in volume 5D. The judgments which were common, my lord, we have been told to take out because they are already on record. Now, my lord, there are two ways in which this matter is being analyzed now, my lord. So I'll just summarize very briefly, my lord. I am not adding, my lord, submissions to the first limb of the argument, which is based on the proposition that all alcohol is intoxicating liquor. And therefore all alcohol is under entry 8 except excise, which takes out a part of it.
No, entry 8 has no fiscal ramification.
It doesn't have. In any event, the fiscal ramifications are expressly provided for.
And provided under separate heads.
Completely separate heads.
No, because you said except excise.
Yes.
That you need not.
No, that's
not
right.
necessary.
That's not the end use of the product.
Your basic point is that all alcohol is intoxicating liquor and falls under entry 8.
Yes, my lord. Therefore, my lord, it is excluded from entry 24. My lord, I am just summarizing, my lord, what Mr. Dwivedi has already made it very clear to your lordships, my lord. So it's not included within entry 24, therefore not included in 52, this one. And therefore, Lord, the entirety of the control should be with the state. So, will I adopt that? I don't add anything more to it. The second aspect of this matter is, Lord, if your lordships do not accept that all alcohol is intoxicating liquor within our entry 8, then what is the position? And my lord, it should be pointed out, my lord, that this proposition was not accepted in synthetics, and so therefore your lordship will have to overrule synthetics on that aspect, that all alcohol is intoxicating liquor.
Mr. Datar left. Mr. Datar, you have to give us that Benion's citation on public law. Yes. Because that issue has also arisen before us in the AMU case. Of course, that the issue is a little different, which, and we're not deciding it or commenting, since both the solicitor and attorney will have objections if we did that, as to whether the union can do anything other than to support the union law. Can the union say that a union law is not a valid law? So broadly, jurisprudentially, the same thing. You know, in that AMU case, that issue, Mrs. Datar had a point because, you know, in synthetics, the union supported Balsara, and said that entry 8 covers both liquor for human consumption and what is now called as industrial denatured spirit. So Mr. Datta wanted to refer to an article by Francis Bennion in Public Law, jurisprudential article. Attorney is also interested in jurisprudence, so it's really interesting to see what is. So volume.
Volume 5, capital E.
Okay.
PDF page 41.
Just 1 second. Let me see where we are taking.
5-E.
Very important. Volume 5G page.
PDF page 41. Public Law Volume 2007. Lordship asked, colleague just found out this executive estoppel, same article has been cited by Justice S.B. Sinha in 2 judgments, 2008, 12 SCC 466 and 2009, 16 SCC 569.
2008.
12 SCC 466 and 2009, 16 SCC 569. His Lordship-
SCC 5.
569. 2009, 16 SCC 569. both by Justice S.B. Sinha.
So you are on the second point now.
Yes.
And you said that alternately, the court does not accept that all alcohol falls under entry
Yes. In that case, Lord, synthetics has to be overruled on the simple ground that the threefold classification of Tikaramji followed up to today has not been taken into consideration at all.
What is the threefold classification of raw materials,
Raw materials,
manufacture and distribution?
manufacture and production, and post-production. Pre-production, production, post-production. Only the second, that is production, is covered by the word industry. So therefore, my lord,
Post-production goes into entry 33.
not necessarily, my lord. It
Trade
first,
of commerce. Trade of commerce
it goes into 26,
27
26 and 27.
or 33.
It might go to 33 if the product itself is a notified industry.
Right.
The product,
The product.
not my lord, the product. Let us say in this case, industrial alcohol is the product. Let us assume. Denatured spirit, my lord, is the better word, as Mr. Datar has already pointed out.
The products of any industry,
Yes.
where the control of such industry is declared by Parliament.
That's right.
So it has to be the product of an industry which is declared by Parliament to be.
Correct. my lord. And if raw material is not that industry, it's not part of the industry, it might itself be a product.
Yes. It can be a raw material for some other product.
In this case itself, let's go straight away into the Lord, the real problem. The nub is here. Your Lordship has seen the process. It starts from molasses, it goes to ENA, extra neutral alcohol. Extra neutral alcohol is then capable of use in two ways. First, by using denaturing compounds, it can become denatured alcohol and can only be used for industrial purposes. It cannot be used for consumption. Second, that same ENA can now be used for processing into potable alcohol. Now, assuming that your lordships do not overrule synthetics on the question of what is intoxicating liquor, what synthetics said was that in order to be intoxicating, it must be for human consumption, because the word intoxicating indicates that it is for human consumption. That, my lord, my learned friend has argued in detail, should not be the correct interpretation because of the legal meaning given to the phrase intoxicating alcohol, intoxicating liquor, long prior to it, including Balsara, etc. So, my lord, by overruling Balsara, synthetics said that intoxicating liquor means for human consumption. If so, my lord, entry 8 at the very least will protect the state's rights on all aspects as far as potable alcohol is concerned. Now,
You said that synthetics overruled Balsara by holding that intoxicating liquor covers liquor for human consumption.
right. If your lordship lord does not accept my learned friend Mr. Dwivedi's argument, then that part of synthetics will continue to hold. That will not is the springing point or starting point for the second set of arguments, my lord. The first set of arguments, my lord, is complete if your lordship accepts that intoxicating alcohol includes, intoxicating liquor includes all alcohol. Then you don't have to go into this second argument at all. But the second argument is also important because, my lord, the judgments so far have accepted that position and carried on after synthetics, naturally. Even under that, entry 8 would at least cover the entire process as far as potable alcohol is concerned.
Yes.
And my lord, here there is a little footnote. Whether or not we look at the amended IDR Act, that would be the position. Before amendment, the schedule to the IDR Act said fermentation products, alcohol, and the second heading. Even here, if intoxicating liquor included only potable alcohol, even then it would not be industry, it would not be subject to 52. Potable alcohol.
So if potable alcohol is covered by entry 8, can't go to entry 20.
Can't go to entry 20. This has become even clearer after the amendment because the schedule now excludes potable alcohol categorically. But that was actually the position even before.
Post 2016, in any case, potable alcohol is out.
Because, my lord, it is no longer a notified product.
Right.
Now we then come, we are left with, my lord, denatured spirit.
Yes.
Most of the process for manufacturing denatured spirit is common to the manufacture of potable alcohol. In fact, I am not saying theoretically.
Yes.
Up to the stage of ENA, there is only one process.
Yes.
If the state imposes any regulations in the manufacture of ENA, it cannot make a distinction between the end product at that stage. At that stage, it is not known what is the end product.
Yes.
So, my lord, Justice Jeevan Reddy in Bihar Industries said that at the point of removal is the appropriate point at which you have to look at the end use. Whatever goes for the manufacture of denatured spirit will remain in the control of the union, and whatever goes for production of potable alcohol will remain in the control of the state. But up to the point of ENA, whatever is done as far as potable alcohol is concerned will necessarily also happen as far as denatured spirit.
Because it is after the ENA stage that the denatured is added.
That's
the bifurcation.
the bifurcation takes place after that. So we'll not suppose, and I give you a lordship a concrete example.
What is the sequitur, Mr.?
Well, just one concrete example. Several states, my lord, have certain restrictions on the input-output ratio of molasses to the final product ENA. If it is within the efficiency factor, then there is no measure. If it is outside, it becomes subject to penalty. Now, my lord, if the state imposes a efficiency factor in the process of manufacturing ENA, at that stage, it will get imposed both on the quantity which will ultimately be used for rectified spirit as well as the quantity which will ultimately be used for potable alcohol. So therefore, my lord, keeping that reality in mind, my lord, we have to proceed to the next stage to see where the control of the state should end and where the control of the union should start. Up to that point, it becomes impossible to make that distinction because whatever I do for potable alcohol will necessarily also apply to the manufacturing process for ENA, which is ultimately used for denatured. Therefore, now let us look at the legal analysis. This is a practical difficulty. Now let us look at the legal analysis.
What happens after the process after the denatured is added?
Yes. After denatured, the product has already come into being. So there, my lord, the the denatured spirit is actually in that second stage. Production and manufacture has been completed now of that product. After that comes the question of distribution, which will go into NT 33. Why? Because denatured spirit is certainly excluded by the schedule of IDR. So, my lord, the notified product, if I may put it that way, the notified product is the denatured spirit. Now, if I apply, my lord, Tikaram, the raw materials used for the notified product, denatured spirit, ENA, is within the state's power. The distribution of the product is within the state's power. And my lord, it is very important. For the reason, my lord, that even denatured spirit, as a matter of fact, can re-enter, my lord, or try to re-enter the potable zone and create havoc. So, my lord, if the state has no power to regulate what happens at the distribution stage, then, my lord, there can be havoc. What is ultimately causing all these huge tragedies is where denatured spirit diluted with water, mixed up with some genuine spirit like whiskey, cheap whiskey, is then sold, and that creates havoc. It can be done. No, even ethyl alcohol. That's right. That is, you're saying that because it is in order to make it denatured. Yes. And Lalifel is saying that in order to make it denatured, you make it methylated, you add methylated spirit, then it becomes denatured. It should not be used for human consumption anymore, but in the market it sometimes comes back, and by mixing it with some cheap whiskey, it is sold. So the distribution is also a very, very important stage, not only for revenue purposes here. Here, entry 6 becomes absolutely important because public health is a state subject. Entry 6 of this. So, both under entry 6 and entry 8, it becomes necessary for the state to control the entire process of potable alcohol, which sometimes goes across to the question of to the control of the denatured spirit process as well. That's the factual background. Now, therefore, if I have to analyze it now in terms of Tikaram, we'll put it into these three components, and only the middle component will be subject to union control, and the other two will either be state control, because it is state control because of 26 and 27. Now the question is that if the product itself has become included in the schedule, ENA, suppose ENA becomes included in the schedule, then of course it will go to 33.
Right.
So far, the only thing in entry 33 will be denatured. That's the product which has been put there.
Yes.
Now, the simple point is, if you do not take into account Tikaramji's analysis, then you cannot reach the correct result. And Tikaramji has not been taken into consideration in synthetics. And the reason, I am sure, is as Mr. Datta said, it was actually a matter relating to tax. It all started with some provision of tax which was under challenge. It could have been decided on a much simpler basis perhaps, but 7-judge bench, so it went into all issues which were argued. Now, one more thing, one passage from Bihar Industries, Give me your page. Volume 5, page 72. 5D, page 72. 5A. 5A, page 72. Oh, because it was in the previous compilation. Not in my compilation, it is already there. Bihar Distillery. Bihar Distillery,
5A 72 is VAM organics.
76.
76, PDF page 76?
Yes, Bihar Distillery is 76.
Yes. Actual page is 72. Here, let me just place 23. I won't take your lordship's time. Para 23. We are of the respectful and considered opinion. PDF page 91. We are of the respectful and considered opinion that the decision in synthetics did not deal with the aspects that have arisen for consideration herein, and that is mainly concerned with industrial alcohol, that is denatured rectified spirit. While holding that the rectified spirit is industrial alcohol, it recognized at the same time that it can be used for obtaining country liquor by diluting it or manufacturing IMFL. When the decision says that the rectified spirit with 95% alcohol content VV is toxic, what is meant is that if it is taken as it is harmful and injurious to health. By saying toxic, it does not mean that it cannot be utilized for potable purposes, either by diluting it or by blending it with other items. The undeniable fact is that rectified spirit is both industrial alcohol as well as a liquor which can be converted into country liquor just by adding water. It is also the basic substance from which IMFL is made. Denatured rectified spirit, of course, is wholly and exclusively industrial alcohol. This basic factual premise, which is not and cannot be denied by anyone before us, raises certain aspects for consideration, herein which were not raised or considered in synthetics. Take a case where two industries A and B come forward with proposals to manufacture rectified spirit. A says that it proposes to manufacture rectified spirit and then denature it immediately and sell it as industrial alcohol, while B says that it will manufacture rectified spirit and utilize it entirely for obtaining country liquor and for manufacturing IMFL from out of it or to supply it for to others for the said purpose. According to synthetics, next page, Lord, A is under exclusive control of the union and only power the state are those which are enumerated in para 86. Those Lord, were the limited powers which was given to the state under that judgment. But what about B? The rectified spirit manufactured by it is avowedly meant only for potable purposes. Can it yet be called industrial alcohol? Can it still be said that the state concerned has no power or authority to control or regulate industry B and that union alone will control and regulate it until the potable liquors are manufactured? The union is certainly not interested in or concerned with manufacture or process of manufacture of country liquor or IMFL. Does this situation not leave a large enough room for abuse and misuse of rectified spirit? It should be remembered that according to many states before us, bulk of the rectified spirit produced in their respective states is meant for and is utilized for obtaining or manufacturing potable liquors. Can it be said, even in such a situation, that the state should fold its hand and wait and watch till the potable stage is reached? Yet another and additional circumstance is this: it is not brought to our notice that any notified order has been issued under 18G of the IDR Act regulating the sale, disposal or use of rectified spirit for the purpose of obtaining or manufacturing potable liquors, which means that by virtue of entry 33 of this 3, the states do have the power to legislate on this field. Field is not occupied by any law made by the union. And we'll the next two sentences beyond that, Lord. The line of demarcation can and should be drawn at the stage of clearance and removal of the rectified spirit, where the removal of clearance is for industrial purpose. The levy of duty of excise and all other controls shall be of the union, but where the removal clearance is for obtaining or manufacturing potable liquors, the levy of excise and all other controls will be of the state. This calls for joint control and supervision of the process, etc., etc. Now, Millard, I come to the next proposition.
Yeah.
The next proposition is this, Millard, and this was actually highlighted in the questions which were referred in the Lalta Prasad order, and that was, Millard, with regard to 18G. The reason why it is being referred is, Millard, two things happened in synthetics. It was said that because it has gone into 52, the entire field is denuded, and so therefore 33 will not apply to give states any leeway. And secondly, that 18G is an indication that it has denuded the whole field. Now, Millard, a very simple, Millard, aspect to be taken into consideration is that 18G was in the statute books all along from 1953 or so. Now, even when Tikaram Ji was decided, it was there. Every time Tikaram Ji, Millard, has been upheld, it has been on the face of 18G. If so, Millard, how could raw materials go out? How could distribution, etc. go out if the whole field was denuded? So, Millard, what has happened is, if you do not look at Tikaram Ji's judgment, you will think that it is possible to hold that the field has been denuded. But if you look at Tikaram Ji and follow it through, then you cannot hold that the field has got denuded. Because, Millard, at least two aspects, Millard, are out. Now, Millard, we have given the list of all the judgments which has followed Tikaram Ji up to ITC. Millard, I am not, Millard, taking your lordship through those. There are just, Millard, there is only one more aspect, Millard, which I want to point out, and this is also, Millard, because of, Millard, specific difficulties which may arise later on. At this point of time, we are not discussing any specific statutes with relation to, Millard, this aspect, but, Millard, if your lordship holds, and to the extent that your lordship holds, that the state has the power to impose regulatory measures it may take the form of matters other than regulatory fees. Moment we say fees, it becomes, my lord, a situation where you might be asked to show quid pro. Yes. Cost of regulation, my lord, must be shown to somehow have a correlation with the amount imposed. It may be a vague correlation or a loose correlation, but correlation has to be there. Whereas, my lord, in fact, regulatory measures may include, my lord, some kind of penalties to discourage a person from doing something. This is not something which is fees and therefore requiring quid pro. So, my lord, all that I am saying is, my lord, that your lordships, if regulatory powers remain with the state government for whatever reason, my lord, then, my lord, such regulatory powers should not be restricted to regulatory fees.
Yes.
My lord, those are my submissions.
Thank you, Mr. Gupta.
Hmm?
Mr. Giri?
Yes, my lord, licensing is a very important way of regulation. So that, my lord, also, and as your lordship has heard from Mr. Datta, the states, my lord, in fact, are my lord, the licensing authority for all industries, my lord, which are manufacturing ENA today.
May it please the Lord. I beg to appear in civil appeal number 6708 of 2014. I think that is 901.14. 14 and 117, let's see, on behalf of the state of Kerala. Lord, the impugned judgments were passed on the basis of synthetics and chemicals, without getting into any other issue. That's why, my lord, when the appeal was filed, the appeal was admitted and, my lord, tagged along with the matters which are already referred. My lord, see, my lord, my written submissions are contained in volume 1, 1D, D for Delhi. There's one other point, my lord, which arises from a judgment of Constitution Bench of this Honorable Court, which has not been referred to, but which arose from the same enactment, my lord, that has been considered. I'll take your lordships to that in a moment, my lord. See, I have given, my lord, the citation to the court master so that it is not part of the compilation of judgments, but I think that it has been uploaded. See, but permit me, my lord, to make a basis for what I wanted to submit before your lordships. My lord, if your lordships were to consider that an industry which is engaged in the manufacture of alcohol per se, without coming to the distinction of whether it is potable alcohol, industrial alcohol, or, my lords, the industrial alcohol in the sense that it is unfit for human consumption, then, my lords, your lordships may construe 24, entry 24 of list 2. My respectful submission is that it would not take in, my lord, an industry which is regulated, my lord, by entry 8, my lord, of list 2. And intoxicating liquors, my lord, which is the prime question that your lordships have formulated for consideration, as falling under entry 8. Whether it would take in all, my lord, subsects of alcohol, except denatured spirit, my lord, which has to go out of, my lord, the purview of
alcohol fit for human consumption or which could be made fit, my lord, for, because then it would, according to me, my lord, it would not be an intoxicating liquor per se. Denatured spirit can never be treated as intoxicating liquor per se.
So there is you're arguing something at variance with what.
Yes, according to me, intoxicating liquor cannot take in denatured spirit per se. This is what I have tried to say, my lord, in my written submissions also. Except denatured spirit, which is a matter of manufacture. All other aspects of all other varieties of liquor would come under entry 8. Every activity which would be comprehended by an industry relating to any product is textually not covered by entry 8 insofar as intoxicating liquors are concerned. Production, manufacture, possession, transport, purchase, every aspect of. Therefore, my lord, entry 24 will have to exclude, my lord, intoxicating liquors. Entry 24 of list 2. My lord, two hypotheses will not flow in my respective submission. Going by 246, Article 246, and the general principles, my lord, which your lordships have laid down in innumerable decisions as to how to construe an entry in a list. My lord, the scope and ambit of entry 52 of list 1 will have to necessarily exclude any item, my lord, which is comprehensively covered by an entry, my lord, in list 2. And here, my lord, 24 would go out of the picture.
Now, what happens to denatured spirit then?
Denatured spirit, my lord, requires a manufacture of a specific commodity which does not become the raw material, my lord, for any other alcohol. My lord, there is no question of
Therefore, point to denatured spirit will be governed by IDRA?
Yes.
52. 52.
Yes. The sequitur, my lord, is therefore, except denatured spirit, every other sect of alcohol, whether it is a final product or an intermediate product, would be covered, my lord, by entry 8. Let alone the question of levy of excise duty under entry 51. In fact, my lord, entry 51 of list 2 is treated to be complementary, and that's what your lordships have held in the judgment, to entry 84 of list 1. Because 84 of list 1, my lord, as it stood prior to the 101st Amendment, specifically excluded it. And 51 specifically provides for it.
Spirit can come both under entry 24 list 2 and entry 33 list 3.
No, my lord, see. Entry 34 list 2.
24.
Entry 24.
Because if denatured spirit is not part of intoxicating liquor according to under entry 8,
Yes.
then the sequitur will be that denatured spirit is governed by the schedule to the IDRA.
If it comes under entry 24, then it becomes subject to 52.
Yes.
Right. So in which case it becomes part of item 26. If it does,
Yes, yes.
right?
Yes, yes.
If it does, it's directly governed by entry 33 of list 3. It's a
Yes.
product of an industry,
Yes.
the control of which is declared by Parliament to be
Yes.
in the
Yes.
public interest.
Yes.
In which case it would still be within the state's regulatory power until Parliament were to enact a law to the contrary.
Yes. Yes. Until Parliament were to enact a law, my lord, in terms of.
BTNG also requires a notified order.
It requires a notified order. There's no notified order.
The little nuance which you are putting, I mean, not a little nuance, but the difference from what everybody else has argued is that according to denatured spirit is out of entry.
Completely.
But are you therefore arguing that Balsara is wrong?
My lord, Balsara really did not consider the distinction. My lord, Balsara went into the question of why does the provisions, my lord, which provided a restriction on the import of not rectified spirit, not denatured spirit, but liquor as such. And therefore, there was no occasion in Balsara, my lord, to consider the distinction. Not only that, my lord, prior to the constitution, all those local enactments, my lord, which Mr. Dwivedi has provided in his chart, all of them, my lord, also define, my lord, spirits as including denatured spirit, and the entirety of control of anything to do with alcohol, including denatured spirit, subject to correction, my lord, came within the province of the provincial legislature. It is only, my lord, when it came under the constitution. Sorry.
Really speaking, Mr. Giri, you are really in that sense arguing the second point, which is the alternate. But the alternate submission which he argued is your main submission, in the sense that you are saying that there is no substance in their first submission. Therefore, the alternate submission is your main argument.
Saying that I am not trying to take away anything from what they have argued. That is something which your lords will have to consider.
But for denatured spirit,
Yes.
your argument is directly contrary to what the others have argued.
In the sense, my lord, but it is not, my lord, in antagonism to that. It is not in antagonism to
No,
that.
but you are saying that denatured spirit does not fall within NT8.
That's correct. Only denatured spirit. I am saying, my lord, I am distinct from 95% ENA, which is what is considered, my lord, in synthetics and chemicals. In fact, my lord, synthetics and chemicals need not have gone into the question of ENA or any other aspect, because the person who had filed a writ petition were, my lord, distillers or were manufacturers of denatured spirit. And it was one, my lord, it was apparently because the license was not granted or some fee was remitted, some fee was demanded, that they had approached the High Court also, even in the first instance in 91. But then, my lord, then the court, my lord, probably because, as Mr. Gupta put it, probably because it was argued before them, the lordship probably felt it necessary to go into these aspects. But otherwise, denatured spirit, according to me, stands completely separately. It's manufactured, my lord, it's manufactured with a process that is unique to it. There is no question of extracting alcohol from denatured spirit thereafter. Nothing. There is no question of comeback. Denatured spirit by itself is a product that cannot be, my lord, used for, and according to me, it cannot therefore come under 8, because it's not an intoxicating liquor. One cannot, my lord, treat the word intoxicating as a surplusage. Intoxicating liquor means it must be fit for human consumption. A denatured spirit is not. Lord, why I beg to, my lord, try to bring it under this entry 8 is because then I don't have to fall under 24. And 24 may not take in anything which falls under 8. And if I don't fall under 24, my lord, I am really not concerned with 52.
Anything other than denatured spirit
Yes.
is something which is, we will not say alcohol fit for human consumption, but alcohol for human consumption.
Alcohol for human consumption.
Which has the potential for human
Yes.
consumption.
Yes. My lord, there's no.
You are paying for the state of Kerala.
Yes. There's no rocket science, my lord, involved in converting ENA, my lord, into my lord, either country liquor or anything, my lord, which is
valid
only
in nature, and that's all.
nothing, my lord, just add water to it, and then, my lord, for the purpose of labeling it in different, my lord, very attractive bottles, you either add caramel, then it becomes rum, you add malt, then it becomes whiskey, and then the others I don't know.
Mr. Giri, it's your theoretical analysis of the subject, therefore.
I'm saying I'll go by what Mr. Datta has provided in his chart. At page 12 of his written submission, he has provided this is
You
how
clarified by Mr. Datta has provided in his chart, not what Mr. Datta has provided.
No, I use the word chart.
So I think we got the point. But therefore, you take it that you are playing for the state of Kerala, right?
Yes.
Therefore, you are not seeking to regulate or impose any regulatory fees on denatured.
No, yeah. The issue, my lord, in the present case arises from, my lord, a demand for wastage fee on extra neutral alcohol.
So the wastage fee on it.
Yes. And that is how, my lord, it has come. No, my lord, there are 2 or 3 aspects, my lord, which may flow out of it, my lord. Can I proceed with it?
Yes.
No, my lord, insofar as the judgment in synthetics and chemicals are concerned, my lord, if Mr. Datta has taken your lordship's, my lord, to some of the paragraphs, my lord, which in his submissions, my lord, he said is, my lord, will have to be treated as not acceptable, and therefore, my lord, has urged your lordships to consider whether they have to be overruled. My lord, could your lordships kindly come back to synthetics and chemicals, my lord, because at the end of the day, your lordships are considering the correctness of the judgment.
question only. We will not go into the the nitty-gritty of your particular
Yes.
provision, the wastage fee, as you say.
Yes. Sorry, is that, I'm sorry, but I didn't catch you.
No, I mean, we need not go into state-specific legislation here. We are
No, we need not. We need not. This is only, this is an additional thing to the board, if your lordship would kindly consider it that way. Without taking away anything, my lord, from the broad sweep of the argument which Mr. Dwivedi had made, that the alcohol which is mentioned in entry 8 would cover everything, every variety of alcohol.
other than denatured spirit.
In my respectful submission, it cannot include denatured spirit, my lord, because entry 8, my lord, makes it intoxicating liquor. And my lord, if there is one product which cannot be treated as intoxicating, my lord, intoxicating would mean intoxicating for the human being, which means it must be consumed by the human beings. And it cannot be. There is no process by which a denatured spirit can be made into, my lord, consumable alcohol, as it were, or potable alcohol, as it were. And therefore, my lord, entry 8 will have to exclude that. Except that, if every other variety is therefore included in entry 8, my lord, the sequitur in my most respectful submission, forgive me for repeating, my lord, I don't have to concern myself with entry 24. And if I don't have to concern myself with entry 24, then really speaking, my lord, I don't have to concern myself with 25 or 27. Because every aspect of it is, my lord, covered by entry 8. Because, my lord, I fall under entry 33, my lord, I have to take resort to entry 33 only when the Parliament may by law, my lord, declare that any industry is one of public interest as such. Where therefore, my lord, the Parliament cannot.
Therefore, when you say that therefore denatured spirit
Yes.
does not fall in the fold of entry 8,
Yes.
it necessarily therefore
Yes.
may fall under entry 24 and therefore under entry 52.
Yes.
But
Yes.
if it falls under entry 52,
Yes.
then the state's regulatory power, even insofar as denatured spirit,
Correct.
would be subsumed in, say, entry 33 of this.
Correct. Correct, my lord, it could. But my lord, in my respectful submission, it is not necessary to get into that orbit at all, my lord. If your lordships are pleased to hold that the intoxicating liquor as contained in entry 8 would contain any other species of alcohol, as it were, except denatured spirit, because it can never become. My lord, manufacture is the ultimate stage, my lord, of a production. A production, therefore, my lord, would have intermediate stages. ENA, my lord, is one of the products which you get in the manufacture of, my lord, Indian-made foreign liquor. Molasses is another product. And from molasses, my lord, fermentation takes place. Extra neutral alcohol is obtained, which could be 95.5%. But that's alcohol, my lord, which would still fall within the ambit of.
The state of Kerala's position, therefore, that the states will not have any role whatsoever to play in regard to denatured spirit.
No, my lord, in my respectful submission, if this argument, my lord, even otherwise, my lord, we don't do anything with denatured spirit. That's what I want to get myself clarified. We have nothing to do with denatured.
You may not be doing it, but ultimately, what is the submission
Matter of states' powers.
about
States
power?
powers, my lord, states powers. For example, my lord, for setting up a manufacturing unit of denatured spirit per se. Lord, I don't think they have to. They have the power to issue a license, and therefore they don't have the power to regulate.
No, but licensing, as you are told, is for the alcohol manufacturing.
Yes.
Right? At the stage when license is issued, it is not issued for industry A, industry B, two categories. It is issued that the end product will determine whose control it will be.
There, my lord, there is.
Therefore, at the time of issuing license, that's what
Yes,
we are given to understand.
Yes, my lord. Suppose it is for manufacture of extra neutral alcohol per se, then obviously the state would have the power. But the question as to whether it gets into denatured spirit or not comes about at the stage of clearance.
That's right.
That's insofar as the taxing power is
At the
concerned.
time of issuing license, the distinction is not there.
My lord, they have to say what they are going to manufacture.
No. Also, an example was given. Let us say at a given point of time, an industry license it has,
Your lordships are
it
right.
is manufacturing, and there is a
It's correct, your lordship.
prohibition is
Your lordships are
imposed,
right.
say Bihar.
Yes.
Then what happens? He has a licensing, he has a factory, But that demand for the product is not there. For the portable, which gives a kick.
Yes.
No demand for that. Then
No, my lord. He has a license for manufacturing, he has a license for producing extra neutral alcohol. But does he have the license, my lord, to produce denatured spirit?
denatured spirit is at the stage of removal.
No, denatured spirit is also a product of.
Also a levy, we are told, or at the stage of denaturing, you are imposing a fee that now you are putting denatured elements.
That's only, they say that that's at the stage of clearance. Therefore, when it gets into the stage of manufacture of denatured
Up
spirit.
till the factory gate,
Yes.
up till the factory gate, it remains in the purview of the state.
In which case, my lord, in which case, insofar as regulatory control is concerned, if it falls outside entry 8, it could still fall, my lord, under 24. In which case, it will be subject to, my lord, to entry 33, 52 and entry 33. My lord, I really don't have to go to that extent, my lord, insofar as all other varieties of liquor except denatured spirit is concerned. It's only for that purpose that I say. But what fell from your lordships that the fact that it doesn't fall under entry 8 does not completely take it out of the purview of list 2. Your lordships are right. It could then fall under entry 24. You say it's an industry. If it falls under entry 24, my lord, it is then subject to entry 51 or 52 of list 1. If it is subject to entry 52 of list 1, then it is subject to entry 33 of list 3. In which case, my lord, possession, transport, and all those things, my lord, could come under the regulatory control of the state as well. I am saying, my lord, I am taking it from the point of view of exclusion, my lord. Except denatured spirit, all other varieties of alcohol would come under, and we are really concerned with intoxicating liquor fit for human consumption in this. For human consumption. My lord, my attempt is only this. Bring it under entry 8, then I don't have to come and I don't have to bother with entry 24. If I don't have to bother with entry 24, then I'm not bothered with entry 51 also. And then, my lord, entry 33 of list 52 also. Then I don't have to bother with entry 33, my lord, of list 3. For all varieties of alcohol, which would come under the broad category of intoxicating liquor, under which rectified spirit will never, I'm sorry, my lord, denatured alcohol will never come under. The other sequitur, the other consequential question, would your lordship then say denatured spirit is completely taken out of the purview of list 2? No. Your lordships are right. But I really don't have to labor on that because in my respectful submission, my regulatory control is on the question of, my lord, the potable or intoxicating liquor, which is fit for human consumption.
That's all, Mr. Giri?
No, my lord, I need another 15 minutes.
Okay, 15 minutes, and then now we only left with Mr. Shraddhan Farah, sir.
Mr. Balbir Singh was
10 minutes, 15 minutes, and then
not more than 20 minutes.
But Mr. Giri, you are sitting here from yesterday. So arguments of Mr. Dwivedi did not have intoxicating effect on you. You are adding something contrary to that.
I don't know, sir. They have the potential. They have the potential of doing it.
So, Mr. Giri, you are suggesting that entry 8 gets kicked in only when the liquid has the potential to give a kick.
Give a kick.
that's wonderful.
That's another facet of constitutional interpretation. Great.
सर्विसिंग डन सर, अब बढ़िया कूलिंग होगी।
यार ये कूलिंग इतनी हो नहीं रही है।
हो रही है सर,
मैं बता रहा हूँ नहीं हो रही है।
परफेक्ट कूलिंग है सर।
गया